Well, good morning, everyone, and welcome to a session of the 5th District Court of Appeals. As the Marshal indicated, my name is David Monaco, and this morning I have the pleasure of serving with Judge Richard Orfinger to your left, and we have a guest from St. Augustine today, Judge Clyde Wolf, who is a circuit judge sitting by assignment from the Chief Justice of the Supreme Court here today. We have 3 cases scheduled for oral arguments. There is one criminal case. That case will have 15 minutes, and there are 2 civil cases. The parties will have 20 minutes aside for those. If the appellant wishes to reserve any time for rebuttal, please let me know, and I'll try and give you a heads up, although there is a clock on the podium, as you know. Finally, if anybody has any kind of device that has an on-off switch, if you would please turn it off right now, that would be very helpful. Exceptions would be, like something to stop a cardiac arrest. But beyond that, let's turn them off. All right, let's begin then with our first case, TEAGUE versus State of Florida.
May it please the Court, I'm Dan Senior. I represent Todd Teague. I represented him below at the trial, and of course he's the appellant up here. I believe the issues and arguments are clear in the briefs.
You want to reserve some time, Mr. Senior?
Well, I do, Judge, and I was going to mention that in a minute. I got just a very short comments, and then I want to reserve all the rest of my time if I may.
Okay, that's fine.
As I stated, I believe the issues and arguments are clear in the briefs. The reason I ask for oral argument in this case is for 2 reasons. One, to advocate that a written opinion be issued. 2, that the 5th District Court of Appeals, in the written opinion, shows that it's in line with the other courts of appeal on the issues which I think are favorable to the defense. This is a case where the state, in effect, is shooting the messenger because they didn't like the message, and we all know that's wrong and it's a fallacy of logic. My client did not steal a check. He didn't counterfeit it. He didn't sign it. He didn't deposit it. He didn't know it was no good. In fact, he was told it was good by the bank, and so he was instructed by others to tell the bank what to do with the money, and then he was arrested. Then he learned the check was no good. He's an unwitting dupe. The state wants to punish him for acts done by others because apparently they can't develop a case or prove it against others. I'd like to reserve the balance of my argument.
All right.
Unless there's some questions. I'm sorry.
No, you're good. We have about 13 minutes and 20 seconds. All right, we will hear from the state.
May it please the Court, I'm Wesley Height, and I represent the state in this case. The only issue addressed by the appellant was the judgment of acquittal in this case. I think that the review of the record will show that the argument by the defense was extensive in that regard. I think the court succinctly summed up what it viewed the facts were and allowing the case to go to the jury. You have a check that's deposited into an account with 57 cents in it, a check of $125,000 plus. You have the defendant himself personally withdrawing funds from that account several times. He comes into the bank, asks that the hold on the large amount be released, and then attempts to send the money, $120,000 worth of the money, to another account. When that fails, his parents come in the very next day and withdraw themselves. It's a joint account. The parents withdraw themselves from that account, and then the defendant comes back in and attempts again. Is described as very nervous. This was strange enough. They called the person who had written the check, and the person who had written the check said never had met the defendant, had nothing to do with the defendant, had not written a check in that amount. The defendant, upon seeing law enforcement enter the bank, throws up into a garbage can. The facts show the defendant attempting to obtain these funds, had obtained these funds. That's all you need for a theft. And then you take all reasonable inferences from those facts, you're allowed to go to the jury. The other 2 issues were not addressed by the appellant, and unless there's questions in regards to those, we'll let the brief speak for itself.
Questions? Thank you very much.
Thank you.
In rebuttal, perhaps I misunderstood one thing the Attorney General said. Obviously, in the brief, there are 3 separate issues, and I am not abandoning any of those.
I don't think he said that.
Okay, I
think
apologize.
what he said was, since you didn't address them in your opening, he's not going to address them in his.
I understand. Okay, there.
Essentially, you don't get to address them on your.
I understand that, Judge. Thank you. Okay. But again, I'd like to emphasize, especially in the reply brief, it's all covered clearly, and the law's, in my opinion, clear. I'm hoping the court would ask some questions about something, because, again, I'm batting less than 10% on even getting opinions written up here, but that's okay. I understand. You're all doing your job. But if there's ever been a case that I think should never have even been prosecuted and certainly should have been a directed verdict, this is it. I mean, for this person to be held responsible for what other people apparently did, and there's no evidence of how and why. When a bank tells you there's money in your account and you tell them what to do with it, that makes you a criminal, then we're all in big trouble. As I cited in the brief, it can happen to law firms or any other businesses. There should be a reversal. Thank you very much.
Thank you, gentlemen.